Okay, dear students, hello and welcome to this video lecture series on behalf of CLAT SATHEE. I am Dr. Animesh and today we are with a very interesting topic that is of special marriage and Muslim marriage. In the last class, we discussed basics of Hindu marriage and today we are continuing our discussion on marriage with special marriage and Muslim marriage. These are the two marriages that are prevalent and there is a lot to understand, very interesting and very important topic this can be considered because we observe marriages all around us, and obviously special marriage is a very interesting thing. Obviously Muslim marriage also has a lot of mm, misnomers around it. There are, so the understanding amongst poor about the real nature of the same is very limited, so that is why we are having this discussion. So straight away moving forward, first thing that we have to discuss in Muslim marriage is again, it's uncodified. First things first, Muslim marriage in India is what we consider as uncodified law. And when I say uncodified, it means that it is not written in any statute. Like in Hindu law, there is a statute called Hindu Marriage Act 1955. So like that, there is no Muslim Marriage Act. Thus, this is based on religious law. Still, in terms of Muslim law, we are following uncodified law. Just like we have taught law as uncodified, similarly, law related to Muslim marriage is also uncodified. And because it's uncodified, it is primarily based on Shariat law or Muslim personal law that derives its authenticity from Shariat Act of 1937. In India, the Shariat Act 1937 makes the Muslim personal law, Muslim Islamic religious law applicable in India. And the most important source of Muslim law in India, Hanafi source of Muslim law in India is what we called Fatwa-e-Alamgiri, which was compiled by Aurangzeb, which contains the basics of Muslim law in India. Now, just like in the last class, we have discussed that in introductory class, we discussed in Muslim law, there are two primary sects. We have Shias and we have Sunnis. In India, 80% majorities are Sunnis and 20% a significant minority is Shia. Now, Sunni and Shia are two sects. In Sunni, there is a general presumption that all Sunnis in India are Hanafi Sunnis. They follow the Hanafi school of Sunni sect. And in the Shia, they follow Ithna Asariya sect of Shia law. We do not have to go into the technicalities of the same. But as far as law is also considered, there is some difference between Shia and Sunni law. And wherever the law is different, I will specify. But generally, whatever is identical, it is same, I'll tell you. Now, first things first, nature of Muslim marriage. Now, nature of Muslim marriage is considered purely contractual. Justice Mahmood, in one of his judgments, was of the opinion that Muslim marriage is a pure contract. When I say it's a pure contract, it means that it has no religious angle to it, and in the sense that it's an agreement, just like in ordinary agreement we have. There is offer, acceptance, there is consideration, then there is capacity. All those ingredients are there in Muslim marriage. And Muslim marriage is not considered a sacrosanct bond which is for eternity. So that's why the divorce is always an option. Divorce is something that is allowed, although it's not encouraged, but nonetheless it is allowed in very clear terms, and it is not considered a taboo. Just like in Hindu society, obviously, as far as Hindu law is considered, before 1955 there was no divorce. Even after that, getting divorced is extremely difficult, and it's considered a taboo. That is not in the case of Muslim law. Muslim law, whenever the marriage is not successful, the divorce was and is always an option. That being said, we have to understand that since it is contract, it's not a pure contract to be true, because Muslim marriage is something which has a religious connotation, because the terms and conditions should not contradict the religion. In the Muslim marriage, nobody can contradict whatever the terms and condition, what are the duties and obligation that has been fixed as per the Islamic law. Like in husband and wife, they cannot agree that husband will not provide for wife, because it is duty of the husband to provide for the wife. It is considered a sacrosanct duty. So it's a special kind of contract, and also doing marriage is also considered obligatory on Muslim. A Muslim man, it is mentioned in a very authentic hadith that the Prophet said that those who marry are my people, those who refuse to get married are not my favorite. So that's the sense of it. So Muslim marriage is a unique type of contract, but nonetheless, it has primarily contractual features only. It's not a sacrament. It does not require any ceremony, or it's not a religious thing. It's more of a cultural thing. It's how the marriage has to be solemnized. There are very few formalities. A Muslim marriage is a very easy thing to perform. Okay. First thing that we have is the capacity, who can marry, who can get married under Muslim law. There is eligibility of marriage. Obviously, the parties must have the required age, and the age is puberty. The moment a party reaches puberty, that is considered okay for a Muslim man or a Muslim person to get married at the age of puberty. Puberty may it is considered okay. If you have crossed the age of puberty, you can get married as per Muslim. Generally, that age is considered 15 years in India. In India, that age is considered as 15 years, because very difficult to actually find out at what age the person has puberty. Or for a boy, when he gets sexual competence, for the girl when she starts menstruating. So the age is puberty. Obviously, this particular rule is subject to the Prohibition of Child Marriage Act, PCMA Act. But as per Muslim law, the age for marriage is puberty. As soon as the puberty is there, the parties can get married. Secondly is obviously consent. Free consent is required. A marriage that happens without free consent is not considered valid. Even if a child is minor and the consent has to be given, the guardian, wali, can give consent, but then again it has to be a free consent. So consent is something very important. So age and consent are basic requirement of a Muslim marriage. Then how marriage is performed? Now there is something called ijab. Ijab is offer and kubul is acceptance. Ijab is offer and kubul is acceptance. Just like in contract, offer and acceptance must happen. And it should happen simultaneously and in the one sitting. In one sitting, ijab and kubul can happen. When the groom is given an offer that, okay, this woman is being given to you in marriage, in this dower, this much meher is there, so do you accept it? So he says kubul, yes. And there's no requirement of saying it thrice. Even saying it once is sufficient. So do not believe whatever you see in movies that the person will say. See, people say it 3 times for emphasis, but the marriage becomes valid. A marriage happens when both the parties signify their acceptance by even saying it once. And even if somebody says, I accept, that is also considered valid. So ijab, kubul is offer and acceptance that has to be done, just like a contract. And then there is requirement of meher. This is very important to understand. Meher is what we call dower. It's not akin to dowry. Don't confuse dower and dowry. Dowry is something that is that's an evil practice, obviously, that is given by the one party to another party in consideration of marriage. That's a different thing. See, dower in Muslim law, or what we in traditional Roman law it's called bride price or whatever, is like consideration but not actual consideration of marriage. It's a money that is given to the bride by the groom. See, this money is paid to the bride by the groom as a token of respect, as acknowledging her importance, that I'm giving you this much money for the sacrifices that you have made to get married with me. You are leaving your home. So that is given as a token of respect. So that is called dower and meher. That is considered a very important part. Meher is mandatory in Muslim law. Meher is considered absolutely mandatory in Muslim marriage. A marriage without meher, even if it happens, still meher is payable. The court will decide how much meher has to be paid, but meher is nonetheless a right of a Muslim wife. If she's a woman, she got married under Muslim law, she is absolutely has the right to claim her dower. Now, how much dower depends on the parties. The parties can fix the dower amongst themselves, and it depends on multiple factors like the beauty, the piety, the capacity, or all those things of the bride. And the bride and groom, both the parties, they decide the dower. Okay. Generally, dower are considered of two types. One is prompt and one is deferred. Prompt dower is paid at the time of marriage itself, or is paid on demand. Whenever a wife says, "Give me dower," the husband will have to pay the dower. Although deferred dower is paid at the time of dissolution of marriage. If the husband divorces the wife or he dies, in that case the dower becomes payable. That is called a deferred dower. So the parties can choose if the dower has to be prompt or it has to be deferred. Okay. So there are two types of dower. Obviously, prompt dower, which has to be paid at the time of marriage or whenever wife demands, or deferred dower, which is paid at the time of dissolution of marriage. So the dower is must in a marriage. One more thing that has to be considered is there is multiple rules related to maximum and minimum amount of dower. See, under Sunni law, the minimum is 10 dirham. Now, dirham is a currency which is based on the price of silver. Okay. So, silver 10 dirham is the minimum amount of dower that has to be given under Sunni law. There's no limit to maximum. It can be 5 crore, 10 crore, whatever. Under Shia law, it is considered that there's no minimum amount, but the maximum is 500 dirham. So that is something that you can keep in mind, although that's not very relevant for examination. You will obviously get a detail of it when you are in law. But since the issue of dower came, I just clarified it. Okay. Then we have witnesses. Ijab has to be there, Kubul has to be there, offer, acceptance has to be there. There must be dower and there must be witnesses. Under Sunni law, there is a requirement is of two witnesses. Under Sunni law, the requirement of witness is that there must be two witnesses, and the witnesses should be Muslim and of sane mind, adult. And there are two male Muslims or one male and two female. In general law, in general Muslim law, this is a common principle that one male in terms of witness, evidence, and many other aspects is considered equivalent to two female. So either the requirement of witness is that it should be one male or two female or two males. This is the requirement of witness under Sunni law. Under Shia law, the witnesses are not required as such. There's no requirement of witnesses. There are no witnesses, still the marriage is considered valid. Okay. Sunni law requires two witnesses, Muslim sound mind, and either two male witnesses or one male and two female witnesses. There cannot be four female witnesses. One male is required. So the witness is also considered a very essential formality of marriage. Moving on. Now there are certain conditions. Now there are impediments to Muslim marriage. There are two impediments. One is absolute impediment, and that is what we call relative impediments. We'll come to that. Absolute impediment is something that will make the marriage void. The marriage will be absolutely void, or what we call batil marriage. A valid marriage is considered as sahih marriage. Sahih marriage is a valid marriage, and there is something called batil marriage. Batil marriage is when a very essential condition of Muslim law is broken. In that case, it is considered a batil marriage. First things first, what Muslim law completely prohibits is polyandry. Yani, while it allows limited polygamy, and a Muslim man can have up to 4 wives, it is prohibited for a Muslim woman to marry twice. She cannot marry while her one marriage is subsisting. If she already married, she cannot marry again. That is one thing. That is what we call limited polygamy. And there is absolute bar to polyandry. A Muslim man can marry 1, 2, 3 or 4 wives simultaneously, and all will be valid marriages. There is an absolute bar to what we call polyandry. Okay. Then there is also a bar that a Muslim woman cannot marry a non-Muslim male, while a Muslim male can marry a Muslim woman as well as a Jewish or Christian woman. Those are called Kitabiya, people of the book, because in Islam, the Jews and Christians, they are fellow Abrahamic faith. They Jews, Christians, and Muslims, they follow the same idea of monotheism, and thus under Islamic law, it is permissible for a Muslim man to marry a Jewish or Christian female, but it's absolutely forbidden for a Muslim woman to marry a Jewish or a Christian male. So that is what we call absolute impediment, prohibition. Then we have absolute impediment in form of prohibited relationship, who you cannot marry. Now, obviously, you cannot marry your blood relative. Blood relatives में कौन कौन है बच्चों? Lineal ascendants, descendants, uncles, aunts, uncle by blood and aunt by blood. And you cannot marry your a woman cannot marry chacha and mama, your paternal and maternal uncle. Similarly, a man cannot marry paternal or maternal aunt. And he cannot marry bua or masi. At the same time, you can marry cousins. Yani ki the daughters of your uncle and aunt are considered permitted. There's a specific verse in Quran which permits this thing. Okay. So blood relatives में कौन कौन बच्चों prohibited हो गए फिर? That all the relatives who are your lineal ascendants, your parents, parents के ऊपर और नीचे, फिर you cannot marry your descendants. You in collaterals you cannot marry your uncle and aunt or grand uncle or grand aunt. Similarly, you cannot marry your sibling. Now, the siblings generally बच्चों are considered of 3 types. 3 तरह के sibling होते हैं. First is called full sibling. Full sibling is your even both the parents are same, that child, that person is your full sibling. If your mother and father is same, in that case the sibling is called full sibling. Then we have something called half sibling. If the father is same, mother is different, then you are half sibling. And then if the father is different and mother is same, then they are called a uterine sibling. And obviously all 3 are considered siblings, and the marriage is prohibited with all of them. So there are 3 types of siblings: full, both parents same; half, father same, mother different; and uterine means mother same, father different. And marriage is prohibited amongst all of them. Then we have some prohibited relationship in relation to marriage as whom you cannot marry. So obviously you cannot marry parents and children of your spouse. Very simple. You cannot marry parents and children of your spouse. If you have a wife, you cannot marry your wife's mother, grandmother. Similarly, you cannot marry your wife's daughter. Obviously, she is not your daughter, your wife's daughter from previous marriage. She is also prohibited. Similarly, a woman cannot marry her husband's father, her husband's son, or anyone like that. Okay. Completely considered prohibited. And then we have something called fosterage. Fosterage means the razat relationship. Yani ki if 2 children, if a woman, simply let's say a woman, breastfeeds a child below 2 years of age on some several occasions, then that child will be equal to her biological child. है ना, यानी he'll be deemed to be the biological or own son of that woman. If a woman breastfeeds a child, then then that woman is considered foster mother of that child, and this child cannot marry that foster mother, and similarly all set of prohibited relationship will emerge. यानी अब वो आपके माँ की जैसी हो गई जिन्होंने आपको दूध पिलाया, तो अब उनकी माँ भी प्रोहिबिटेड, उनकी डॉटर भी प्रोहिबिटेड, उनकी सिस्टर भी प्रोहिबिटेड, है ना, ऑल दोज थिंग्स विल बिकम प्रोहिबिटेड. So you get a whole set of prohibited relationship if a particular child below 2 years of age is breastfed by a mother. वो फिर उसकी foster mother हो जाती हैं, and it will be considered equivalent that she is his own mother. So that's why it will be considered completely inappropriate and forbidden for this man to marry that woman or any of that close relatives of that woman. So it is called fosterage, relationship of fosterage. Similarly, if a girl child is breastfed by a woman, then that woman's husband this girl cannot marry. That woman's son this girl cannot marry, because again, Razai bhai or the foster brother that will become. So in Muslim law, there is no logic as to adoption, but there is logic as to fosterage, breastfeeding. So if a woman breastfeeds a child, an infant, that infant becomes her foster child, and again a whole set of prohibited relationship emerge. So under Muslim law, there are certain prohibited relationships. Some stem from blood, some stem from marriage, and some stem from fosterage. In Hindu law, we had blood, marriage, and adoption. By adoption, also prohibited relationship is created. If I adopt a child, that child is equivalent to my biological child for all intent and purpose. That is something very important to understand. Okay. Then we have other conditions of Muslim marriage. See, just like we discussed the absolute impediment, we have some relative impediment. Relative impediments make a marriage fasid or irregular. Irregular means if the impediment is removed, the marriage can be regularized. There are some relative impediments which make a marriage irregular, but the moment the marriage is when that impediment is removed, the marriage becomes regular. Okay, and this is only applicable to Sunni law. In Shia law, the marriage is either sahih or batil. There is no irregular marriage. So there is no concept of regularizing that marriage afterwards. Marriage has happened, it is irregular, we will make it regular by removing the impediment. This is exclusive to Sunni law. In Shia law, if it's either valid or void, या तो marriage है या तो नहीं है, तो आप ये बच्चों ध्यान देने वाली बात हो गई. Okay, so it's called relative impediment. So what a relative impediment? A Muslim man marrying a fifth woman. Now that marriage as per Shia law will be void, but in Sunni law it will be considered as irregular. Irregular meaning thereby it can be regularized if the man divorces one of the four wives or one of the four wives dies, then the fifth wife becomes regularized. Similarly, iddat. See, iddat is a very important and interesting concept. Iddat is the period in which a Muslim woman cannot remarriage after dissolution of marriage. यानी कि अगर कोई मुस्लिम वुमेन है, लेट्स सपोज उनको डिवोर्स हो गई, हस्बैंड डिवोर्स्ड हर, now whether she can remarry, the answer is yes, but she cannot remarry immediately. She will have to wait. Generally, in case of divorce, she will have to wait 3 months, and in case the husband has died, she will have to wait 4 months and 10 days. That is called iddat period. This iddat period she cannot remarry, so that the paternity of any child becomes clear. Suppose a woman is divorced today, she marries tomorrow, 9 months after she gives birth to a child, there will be complication, confusion as to whose child that is. That is why a woman is asked to wait for 3 months. so that it can become clear that whether she's pregnant or not. If she's pregnant, then iddat will continue till her delivery of the child. If she's not pregnant, then she is free to remarry again. So this 3 months in the case of divorce and 4 months, 10 days in the case of death is what we call iddat period. During this iddat period, a woman cannot remarry. But so let's say if a man marries a woman during that period, then the marriage is irregular. And suppose afterwards she is not found pregnant, then the marriage becomes regularized. Similarly, we have unlawful conjugation. Unlawful conjugation means it's a tricky concept, but you will all understand. Unlawful conjugation means a man cannot marry two women who are close relatives, in the sense that you cannot marry both mother and daughter. You cannot marry two sisters because they are in such a close relationship that if one of them were male, they could not have got married. जैसे कि दो बहनें हैं, अगर उनमें से कोई एक मेल होता तो वो भाई बहन होते, तो उनकी शादी नहीं हो सकती थी. So you cannot marry two sisters simultaneously. You cannot marry a grandmother and a granddaughter, a niece and an aunt simultaneously, because if one of them were male, they could not have got married. So unlawful conjugation prohibits marrying a close relative of your wife. So that is also an irregular marriage. If you divorce your wife, then you can marry your wife's sister. But while you are married to your wife, you cannot marry your wife's sister. It can be regularized by divorcing your wife, or if your wife dies. But till that time, it's irregular and it has no impact almost. Then without witnesses, if the marriage is without witnesses, it is irregular till it is publicly acknowledged. Once it is publicly acknowledged, it becomes valid. But without public acknowledgement, marriage remains irregular. But that is only in Sunni law. In Shia law, since witnesses are not required, the marriage remains valid. Then difference of religion. जैसे मैंने आपको बताया बच्चों, a Muslim man can marry a Christian and a Jewish woman in a valid marriage, no problem. But what suppose if he marries a Hindu woman, a Buddhist woman, a Parsi woman? Now that marriage is irregular, and that can only be regularized if that woman is converted into Islam. So obviously there is a lot of pressure to convert in those cases. So once she is converted, the marriage becomes valid. So all these concepts are of irregular marriage. Now irregular marriage is exclusive to Sunni law. In Shia law, there is no irregular marriage. Now see, in valid marriage, all the consequence of marriage flows. In the case of void marriage, there is absolutely no consequence of that marriage. Children born will be considered illegitimate, and there is no rights and duties of the parties towards each other. But what about irregular marriage? In irregular marriage, the children will be considered legitimate, but husband and wife, they do not have any right towards each other. There is no mutual inheritance, no right to claim maintenance, nothing. So while the children will be legitimate in the case of even irregular marriage, the marriage will be considered irregular in the sense that the wife will have no right towards the husband will have no right towards the wife. This is very important. Then we have something called muta marriage. Now this is also a very popularly asked question. Muta marriage is exclusive to Shia law. Only in Shia law that is permitted. And muta marriage is the difference between muta marriage and ordinary marriage is, in muta marriage, tenure is fixed. It's a contract, obviously, in which the tenure of marriage is fixed. कि भाई 5 साल, 10 साल, 10 महीने, 5 महीने, 1 महीने, 5 दिन, 6 घंटे. The marriage can happen for a certain duration, and after that duration, marriage automatically dissolves. So muta marriage is a marriage in which divorce or the time limit of the marriage is stipulated. It is considered a bit immoral, but nonetheless it's allowed in Shia law. That muta marriage is permitted and the time limit is fixed. And after that time, the marriage automatically dissolves. Unlike in other normal marriage, there is no time limit fixed, and marriage will not automatically dissolve unless until divorce is pronounced. But in muta marriage, 2 दिन के लिए शादी की, 2 दिन खत्म, marriage खत्म. This is also considered permitted. So this muta literally translated into pleasure. So it's a pleasure के लिए marriage की है आपने. You do not have to, you don't have no desire to live in a matrimonial home and long-term companionship. You just had this marriage for pleasure, and that is considered allowed in Shia law only, not in Sunni law. So remember that. Okay. I hope this much is clear. Now let's move on to a very interesting topic again. Special marriage. Now, special marriage is very interesting because it is governed by what we call Special Marriage Act of 1954. Now, special marriage is a marriage which happens through intervention of the government. If you ask about Muslim marriage or Hindu marriage, it can be solemnized by a priest, a qazi, or a religious person, or anyone for that matter. But whether if you want to have a special marriage, or it is also popularly known as court marriage, in court marriage you will have to go through the mechanism of government. Okay? So the nature of marriage is very simple. Nature of marriage is a secular marriage. It's a marriage in which there is no religious aspect. It is not required that both the parties must be of same religion, caste, community, creed, whatever. The parties they can get married if they want to, provided some conditions are fulfilled. Now, what are conditions that are there applicable to special marriage? First condition obviously is very simple. The parties must be 18 and 21. This is very important. And there's a strict requirement. If a marriage happens or a special marriage is applied, and if the bride is not 18 and the groom is not 21, the marriage registrar will throw your application. Secondly, bigamy. Yes. A special marriage requires that the neither party should have a living spouse. Yani ki, if you are already married to someone else, you cannot perform a special marriage with someone else. If I have already have a wife A, I cannot go and marry a woman B under special marriage. No. Absolute monogamy is the rule under special marriage. Obviously, if my first wife is dead, or I have obtained divorce from her, or if a woman obtains divorce from the husband, or her husband died, then she can get married under special marriage act. There's no problem. That is second condition. Third condition is obviously the parties must be capable of giving consent. Capable of giving consent. If they are not capable of giving consent, there is some insanity, some difficulty. She is incapable of giving consent and unable to understand the nature of the ceremony, what is happening. So if they're insane, then the marriage is not allowed. And fourth, obviously they should not be in a prohibited relationship. They must not be in a close relationship each other. Yani ascendant, descendant, uncle, aunt, cousins, all are prohibited under Special Marriage Act. Although the list is very similar to what we had in Hindu law. You cannot marry the people who are closely related to you. It's a long list. You can go through it. So there are 4 conditions, and these 4 conditions are to be seen. Parties must be unmarried, 18-21, capable of giving consent, and fourth, they must not be doing incestuous marriage. Yani ki incest should not be a factor. Okay. Then process, which is very important. Down the line, if you will become a lawyer, I am sure some of your friends will call you and say कि भाई मुझको court marriage करनी है, बताओ दो कैसे होगी. I get those calls for all the time that you tell me the procedure of court marriage, how special marriage can be performed. The process is very simple. First, you make an application. The bride and bridegroom give a notice of intended marriage to the marriage registrar in a district. Now, the requirement is either party must be living in that district for at least 30 days before the petition is presented. You must be a resident of that place for at least 30 days before you can approach उस जिले का marriage registrar of that district. Suppose I am sitting in Jabalpur and I want to get married in Jabalpur. Now I will have to prove to the marriage registrar of Jabalpur ki sir, we want to get married here, and one of us, bride or bridegroom, have been living here for at least 30 days before. कम से कम 30 दिन पहले से हम यहाँ पे रह रहे हैं, तो सर आप जो है हमारी मैरिज रजिस्टर कर. Suppose randomly I'm in Jabalpur and I go to Delhi to get my marriage registered. I am from Jabalpur, girl is from Bhopal, and we go to Delhi to register the marriage. Delhi registrar will say, no, you either party must be living here for 30 days. If that requirement is fulfilled, a marriage a notice of intended marriage is given to the registrar. Now, in movies होता है ना, अचानक गए और घुसे और रजिस्ट्रार ने फटाफट शादी करा दी, ऐसा नहीं होता. That is all movie, filmy है वो. It takes time. Now the marriage registrar will accept the notice and will display that notice on his notice board. कि भाई, these two people are getting married. Anybody who wants to file an objection can file an objection. Now objection can be filed on those 4 conditions. कौन सी 4 conditions भाई? Bigamy, 18-21, the age must not be 18 and if not 18 and 21. If the girl is a minor, she's submitted a false certificate, whatever. Or if the party is not capable of giving consent, insane or something, some problem is there, some mental element is there, or if the parties are in a closed, prohibited relationship. On those 4 grounds, anybody can file an objection in the front of marriage registrar. He said, these 2 people are getting married and I object to this marriage, but you can object only on 4 grounds. You cannot invent a ground ki, sir, I do not believe this marriage should happen, or this girl promised me that she'll get married to me, now she's getting married to someone else. All those grounds are not relevant. Only on the grounds as per section 4 of the Special Marriage Act, that the party's age, capacity of giving consent, bigamy and incest. On all these 4 grounds, you can file a objection. Now, if the marriage registrar receives the objection, he will decide on it, whether that objection is correct or not. If he finds that the objection is not correct, or if no objection is received, he can simply proceed. He will give a date to the parties that on this day your marriage will be solemnized. If he finds that yes, the objection is correct, he will say that okay, the marriage cannot be solemnized because one of the condition is breached. Now the parties can go to civil court to prove their case, and that's a separate procedure altogether. But if the marriage registrar has fixed a date, on that particular date, the parties can go to marriage registrar's office, or they can pay some special fees and call marriage registrar to their place or any place within a reasonable distance, and the marriage registrar will come. You can solemnize, you can choose any ceremony, माला पहना दें, अंगूठी बदल लें, कुछ भी कर ले, है ना. You just hold each other's hands and say that I want to marry or whatever. Now it does not has to be a religious ceremony or anything. The marriage registrar simply will get your sign on on the register of marriage, and that will be considered it. The parties will be considered married for all intent and purpose. But once you have done special marriage, your personal laws will not be applicable to you. Now you will be governed by secular or what we call special laws. The moment a person gets married under special marriage, all their obligations, all their connection to their personal law, their religious law ends, and now they will be governed by special law and special law only. So that is perfectly all right. So once the marriage registrar gives you marriage certificate, the parties will be considered to be married. So court marriage is not that tricky. It's very cheap. Now you have to pay a little fees. I believe 1,000 rupees if you spend, you can get married under special marriage. No, but it will take some time. Take 1.5 months. You go and you file a notice. Then after 1.5 months, the marriage registrar will call you and get your marriage solemnized. It is not an instant procedure. Like a religious marriage, you can have instantly. Walk into a temple and get a Hindu marriage. Walk into a mosque and a Muslim marriage will be solemnized by the Maulana or the Qazi there. So that is very simple. But a special marriage, it takes some time. But special marriage are cheap and best, and people are preferring. to do special marriages instead of a lavish grand wedding. Whatever, whatever suits the party, whatever floats your boat. So I have discussed basics about special marriage as well as Muslim marriage. In the next class, bachon, we will discuss nullity of marriage and child marriage, and also same-sex marriages will be discussed. Okay, so all those three things we'll discuss. I hope you got some idea about the topics that we're discussing today. Thank you so much for being patient listeners.